Zainab from Gramelis Attorneys. I'm here with Eugene, who's the principal of our firm. Eugene, today we'll be discussing wills and letting us know about why is it important to think about preparing a will.
That's right, everyone, and welcome to the inaugural podcast for Gramelis Attorneys. This is something that we've been thinking about doing for a long time here at the firm. Privileged to have one of the stars of our team here, Zainab, who's an associate here, and we've, as I said, we've been thinking about this for a long time, and we thought what better time to start talking about these things than now with all the craziness that's out there in the world. We've all become no doubt impacted by the coronavirus, or COVID-19 as it's called, and there's every day I see on Facebook posts, I see bulletins, of course we go home and we listen to the news, and there are so many stories and opinions, and there's a lot of information out there, but there's also a lot of misinformation. So the reason why we thought we better start doing these podcasts now is because we want to make sure that people are getting the right information. So we're just going to have a bit of a question and answer here with Zainab, and both of us will be having an input and giving our thoughts on not just what's happening out there, but how it impacts the area that we're looking at today, which is the estates and wills. Zainab, what are your thoughts on what's happening out there and how it impacts what we're talking about today?
I think what's happening out there is once in a century event where there is a pandemic and it's affecting everyone like it hasn't for a very long time. I think this is the first time in my lifetime that we face these circumstances. I think it's difficult sometimes to talk to clients about wills because it contemplates their death.
Certainly not a pleasant topic.
Yeah.
Not for us lawyers or for the people we need to talk to about regarding these things. But it's a conversation that has to be had, and I always say to clients, it's better to think about these things now, get your thoughts in order, get your wishes documented, and then put that document away in a drawer in a safe place, a safe or your lawyer's safe custody packet, and not have to think about it again for a while. I think the important thing, the message that I want to send out there is not to panic. There are laws in place to deal with a situation where somebody might pass away without a will. It's not necessary. There are a lot of myths out there, and one of them is that if you die without a will, everything might go to the state. That happens in cases where there is no other beneficiary that would fall within there's a statutory formula, and at the very end of that statutory formula is the state. But before it gets there, there is a long line of people it needs to get through. So it's not the case that if somebody passes away without a will, that it will automatically go to the state. So there's no need to panic. There is a statutory formula that provides for where assets go, but they may not go to the person that you would prefer them to go to, and there may be unintended consequences by leaving it to the arbitrary formula. So there is a benefit to getting a will done, and that is that you can direct where you want your estate to go, rather than leaving it in the hands of this formula. Another benefit would be that you can put in control of that process, someone you trust, someone that's known as the executor or the trustee, and that is someone you can nominate. Again, if you don't nominate someone, or if you die without a will, then you don't have control over that process. There are still people who are eligible to do that and make that application. It's just that by having a will, you can direct and control and nominate who that person is to be. And normally, and as without saying, it should be someone that you trust, who's aware of your intentions and who you feel will best see them through. Zainab, is there do you have any thoughts on what I've just said? Is there anything you want to add to that?
I might just add that probably another myth that you must come across is sort of young people who are middle-aged, don't think that they should be preparing a will. They're too young, they're not at risk of dying. And so what would you say to young people?
It's a very good point that you raise. Of course, none of us are invincible. And I don't know that, and of course that death doesn't discriminate according to age necessarily, but I think the answer to that quandary is you should be guided by whether you have assets that you want to direct to people that prefer to benefit over others. That I think is the guiding principle here. If you have any assets at all and you want to make sure that those assets go to the persons you would like them to go to, then it's best to do a will. It doesn't matter how old you are, whether you're in your 20s or in your or whether you're born in the 1920s. I don't think age should be the guiding factor. I think what should be the guiding factor is whether you have assets and financial resources that you want to direct to a particular person, and of course if you don't have a will, they may not be inherited by the people that you want to inherit in the proportions you want them to inherit it. And wills can go from being very simple to very complicated, again depending on people's individual circumstances. So you don't necessarily need to sign up for a very complicated will. A basic will is still better than having no will at all, in my view. So, Zainab, if someone wanted to do a will, what are the kind of things that they would need to turn their mind to, the kind of questions? Because we often get people coming in to do a will, but it becomes very obvious in the conference that they haven't actually thought through and haven't got straight in their own minds exactly what they want to do with their estate. But there are some basic, fundamental, I think, considerations that you need to turn your mind to. What would you say is the primary one, Zainab?
I would start from the point where who's going to be the executor? Who do I trust? Or whether you want co-executors, you want two people to be managed, and then we need a backup to the executor. What happens if we survive the executor? So I think that's the point. That's where people should begin. Yeah,
I think it's very common for particularly older couples to come in and say, I want my wife to be the executor if something happens to me, or I want my husband to be the executor in the case of the wife if something happens to me. Of course, they then tend to be of similar age, which means that what you raised earlier may very well occur. That is that the testator, the person who's making a will, may end up surviving the named executor. So you need to have a backup or a substitute executor. So you might come in and see your lawyer, and you might say, look, I want my wife or my husband to be my executor in the event that something happens to me. But in the event that they're not able to exercise that role, or they don't want to exercise that role, then I would want to appoint a backup executor. And as Zainab said, sometimes it's best to have more than one. So sometimes I will go to their children and say, look, if my husband can't do it or my wife can't do it, then I would want my 2 children or 3 children to be executors jointly, which means they've got to make decisions together, or severally, which means that either one of them might take up the mantle and make the decisions themselves, because it may be that some or either of the children can't do it or don't want to do it. So it means that the ones that can and are able and willing can then continue in that role. You'll sometimes hear the word executor and trustee in a will. They mean different. They are essentially the same thing, but have different meanings depending on the context that you're referring to them in terms of the will, got different hats and exercising different functions under the will. We may discuss that a bit later. But so once you've gotten that down and you've worked out who your executors are going to be, what's the next most important thing to think about?
I think it's to identify the property you own,
Mm-hmm.
and I think it's important for you to determine how you want to distribute that. I know I'll get some inquiries about possibly having, like, for example, let's say the client owns a property, he's married, he's got children, and he wants to put a provision in where he wants his wife to have a life estate.
Yeah,
In the property?
they're pretty tricky. They're pretty tricky.
So what would you say to that, to a client who says, okay, I want to take care of my wife, but if, for example, she was to get married, or she, for some reason, he just determines that he doesn't want to give her the property, the entire interest in the property, what would you recommend to the client? Do you recommend that they have provisions in terms of give their partner maybe an income or a life interest in a certain property?
So wills can be, as I said earlier, wills can go from very simple to very, very complicated. There are scenarios where you might want to, rather than give your estate outright to your spouse, you may want to give them the option, for example, of taking some, all or none of it in a trust. So we call these testamentary trusts. They are trusts that, remember we spoke earlier about the executor wearing different hats. And by the way, you can nominate a trustee in a will who is different to the executor, but it turns out as a matter of practice, most of the time they turn out to be the same people, only because people tend to have a limited circle of persons that they trust. So they kind of make their way into the executor's clause, and by default sometimes as trustees. So the executor is in essence the person who's going to take the will to a lawyer and who's going to exercise be your legal personal representative and utilises most of the time the services of a lawyer. The trustee is the person who's going to be making decisions and managing any trust that's created by the will, and that sometimes is because you have children who are under the age of 18 or 21 or 25, depending on what's stated in the will as being the age upon which they will receive any gift. So the trustee will manage the estate on their behalf until they attain an age where they can receive the gift outright. And wills normally allow a lot of scope for powers, and then there's a trustee act as well, which imposes certain powers on a trustee. But a will can confer all sorts of powers on them to keep flexibility, including the release of partial funds for education and for any purpose that the trustee believes is necessary for their education or maintenance in terms of children, or not necessarily as children, but people with incapacities. Now, this is something that you should talk to not just to your lawyer about, but also with your accountant or financial advisor, and sometimes it's beneficial to have a discussion between all three parties with you to come up with a plan that is most tax effective within the legal framework. And that's where the trust comes into it, because you may want to give your spouse, as I said earlier, the option to take part of the assets outright, or all, or leave part of them in a trust, or leave all of them in a trust. And one of the things you would do is speak with your accountant and financial advisor to see if there's any benefit to doing it one way as opposed to the other. But if you don't allow for this in the will, then the option's not there. So you need to lay the foundations for it. That doesn't mean that your spouse is then compelled to take everything in a trust, because trusts have limitations. It limits their ability to, it takes away control to some degree, places control in other people. That's not something that many people are keen to do. But for every benefit, there's often a con, and that's where you need to get advice, holistic advice from all your advisors particularly your financial advisors, not just your legal advisors. But to have the option to do it, and you often allow a period of time in the will for your spouse to go and get that advice and make an election. So creating a trust is one way of maybe letting them have the benefit of income, letting them have the benefit of certain deductions. You can create multiple beneficiaries, you can create multiple trusts. So you can create family or bloodline trusts, as they're sometimes referred to. So a trust, it will continue from one generation to the next until a particular date when the trust vests. That's one way of doing it, and we can get we get into the more complicated and more sophisticated mode of a will. Other ways of doing it, as you said, is by letting them have the benefit of the income from a particular asset, but not necessarily the capital, or corpus, as it's sometimes called, and sometimes creating life estates. The one thing that we need to be careful of is that we're not creating a situation that is going to be difficult to interpret, because what we don't want to leave in the wake of our passing is a long line of litigation between family members. We need to make sure that whatever we draft is clearly drafted, that there is no scope for misinterpreting or scope for interpretation that might result in something different to what you intended. And just, it's got to be reality tested. I think it's all good and well to come up with something that sounds really good on paper, but you need to step back and think, as you know, if the court is going to be scrutinising this because somebody's made a family provision claim, which is a claim that eligible applicants, and there's only a certain class of people that fall within that, but normally close relatives, people who say that they were hard done by the terms of a will and ought to have received a greater benefit under the will, or any benefit in the case where you might have left people out completely. If this is going to be scrutinised by the court, and they're going to be standing back and judging you by the standards of someone who is a wise testator, are they going to say that you've acted reasonably, that you've made reasonable provision here for those people that have been included in the will and have acted reasonably in the way you may have excluded other people? So the way you put these arrangements together will obviously be something that should be reality tested, and is this going to work from a practical perspective? So before you commit this to a legally binding document, you need to give some thought to that. Now, I've often had people as well who've started off with a very complicated document, and then years later will come to review it. And we recommend that wills should be reviewed obviously every time there's a major change in your circumstances. If there's a marriage or a divorce, they can affect the validity of a will. But just if there's any major change in your circumstances, then you should be looking at reviewing your will. But otherwise, you should probably, as a rule of thumb, maybe every few years. Every few years would be a good time to just sit back, and it may be that there need not be any changes, but you need to turn your mind to it, I think, every few years, or earlier if there's some other major change in circumstance. But otherwise, I've had people, as I said, who've done complicated wills, and then they've come back years later and said, we just want to go the other way now, can we just make it very simple? And vice versa, there are people who don't have a lot of assets to begin with. They might only have a family home they're trying to protect, and to make sure that the people that they love and want to benefit obtain that. But then as time goes by, their circumstances change, they acquire more property, their financial affairs become more complicated, and then by a knock-on effect, so does their next will. I think when you do a will, you need to kind of make it perspective. You need to think ahead a little bit. And the more specific you are in the terms of the will, in terms of naming particular properties, the more likely you are to be limiting the lifespan of that will. Whereas if you cast it in more general terms, you're probably going to give it a slightly longer life. But every case is different, and every case should be looked at on its own circumstances.
The other question I've got is, when clients have property in foreign countries, let's say, for example, my father owns property in Lebanon. He makes a will in Lebanon, he makes a will in Australia, each will with respect to the property of that country. How does that interact with Australian law? How does the Australian law?
That's a very good question, Zana. I think people make an assumption that if they do a will here, that it covers all property, and that's not necessarily the case. There are conflict of laws principles that apply. There are very peculiar ones that apply just to assets, just to do with wills and succession, and there's often a distinction to be drawn between movable property and immovable property, and as to which is the appropriate forum, and there are sometimes conventions at play as well. It's a very complicated area of law, and I always caution clients that when they come to do a will, that and they want to cover all. There are a couple of ways to approach it. Most people want to cover all bases in the one will, and I always say to them, look, just to be safe, what you should be doing is making sure there's nothing stopping you from saying in your will here how you would like your assets in another country to pass. But if you want to be sure that that other country is going to recognise what you're doing here, you should probably make a mirror will in that other country as well, or a will that
same terms
as a will that accords with the laws of that country in terms of the execution of that document and the formalities of that document, but also that it reflects the terms of this one as well. Okay. Now, that doesn't guarantee, of course, that there won't be litigation. It doesn't guarantee there won't be disputes. It doesn't guarantee that there won't be arguments about formality. But at least you are maximising your chances of having your intentions, testamentary intentions, implemented. Whereas if you're doing it just in one country, it may, depending on the laws in the other country, be accepted. It may be endorsed. It might be reflective of the same principles that might apply there, might apply here, but you're leaving it to chance, or you get into a very expensive process of having to ascertain exactly what those conflict of law principles are that might apply to that other country, and it becomes a very complicated will and very expensive will, right? So sometimes the easiest thing to do is just make a will here, and then make a mirror one in that other country. And where you might run into some additional problems is, for example, in countries where the law is very radically different, the succession, the laws that apply to succession and inheritance are so different that they are almost completely incompatible. So if, for example, you made a will here that covered property in Australia, and say in a country that may not, in the event that there was a family provision claim here by a relative, that the laws in this country might say, well, that's not compatible with what we understand to be, or what we expect to be reasonable and appropriate provision, right? And vice versa, that if it was something was done in that country that was reflective of what this country might regard as adequate and reasonable provision for a beneficiary, they might say that's completely out of kilter with our standards. So there may be no recognition there simply because of differences in values and differences of expectations. The community standards do end up making their way and do sometimes inform the law. So,
I think one of the other things I was thinking about is people might, in today's day and age, with the coronavirus, be afraid to go to their lawyers and get their wills tested. So can you let everyone know what we've been doing here at Gramelis?
Yeah, that's very good, a very good point, and also it's very topical. So given, we're about 2 weeks into the will crisis, sort of seems sort of unfolded, at least in Australia. It's been on the boil for a while,
yes,
but at least the last 2 weeks, we've been doing most of our, as you can see, we're still broadcasting from the office, but we've been doing a lot of our work remotely. The courts have been doing a lot of their appearances remotely. The situation is very fluid, and we're getting bulletins almost daily from the courts and government agencies saying this is another change we've made and this is how we're doing it now. And it's a learning curve for most people. At the moment, one of the few things that, because of the way the legislation, the way the Succession Act is worded, we can't do remotely is wills. We need to be in each other's presence when we execute, and when the testator executes, when the witnesses are executing. So the few clients we have been letting into the office at the moment are people who need to do wills. Now, as we seem to be almost inevitably moving towards a lockdown, or at least a form of lockdown, it may not be a complete lockdown, and there's some scope to argue essential, what might be essential travel, and maybe this might be one of them. But there are, as I understand it, some amendments being discussed, if they're not, to the Succession Act and wills and the like.
Yes, the Law Society has recommended changes. We haven't received confirmation that those changes have been put into law, but once we do, we will update them. But I think more from a practical point of view, what we've been doing is using a lot of Glen 20, observing the social distancing here in the office.
As you can see, I think this is about 1.5 metres or something.
I think you've signed all of the wills just out there, like on our reception desk where there's a lot of distance. Any clients who have any concerns, and we haven't been allowing people to come in for conferences. It's pretty much only clients who need to sign documents for a very short period of time.
So we've been very mindful and respectful that a lot of the people who are doing wills are the older people, and they're at higher risk. And so we've been asking them to, if they're coming to do a will, for example, sometimes they like to bring support people with them, and we've been saying to them, look, it's probably best that you just come alone, and if you need a support person, we can always get them on the phone. So that's one thing we do. We've been asking people before they come if they've been showing any signs of coming to exposure with people who've been showing any signs. We've been sterilising the pens that they've been using between clients, because they often look at the pen when you ask them to sign, and there's a moment's hesitation before they pick it up, and we've had to assure them, look, we've even sterilised the pens, we sterilise our seats. And we have been ourselves, both within the office and outside the office. Myself and my staff have all been socially exercising social distancing, and have been socially responsible. We've been going from the office to home and not much else, except for maybe some shopping or something like that. But we've been limiting outside activities. So I guess the challenge is going to be moving forward is if we go into a total lockdown, we would need to see what falls within the definition of essential travel. There'll be people who are in need of these, and not necessarily because of the coronavirus itself, i.e. not because they've contracted that, but there are people who are just not well, who are, who want the benefit of, they're old, they're frail, they want the benefit of having a will, or updating a will that's been dated for some time, and the challenge is going to be getting to those people. But as always, we'll find a creative and a safe way to do it. We'll just keep adapting to change, and being on top of whatever the latest amendments are, and making use of technology wherever we can. As far as we're concerned, whether there's going to be a lockdown or not, we're going to continue to be of service to our clients, and that includes any prospective clients or new clients who might need our help. We just need to be patient with each other, I guess, as we work through this. Even if we're required to work completely from home, as I think is going to be inevitable, we are fully equipped, fully geared. Our IT people have been setting us up for the last couple of weeks in anticipation. Everything's being tested and ready to go, so we'll continue to be of service. If you have existing matters with us, we want to assure you that we stand ready and willing and able to continue working on those matters, and with as minimal disruption as is in the circumstances avoidable. But or if it's not avoidable, then we'll do our best to minimise it. But we expect that the courts will adapt, the government agencies will adapt, and they've been adapting quite rapidly, I have to say.
Yes, it's very unusual for the courts. They've always notoriously been it takes them a while to change. Yeah,
I think us lawyers are very slow at adapting sometimes, but I think when a shove comes in the back, as this, I think this has been for not just our profession, but for I think the biggest part of the population. I think it's going to change the way we do things, and some things for the better, even though the circumstances are unfortunate.
I agree.
And quite dramatic, and I think the things that linger with us, the practices that and innovations that will come out of this, I think will be for the better.
Yes, we can file subpoenas online now in family courts.
Yeah, that's right. So, well, is there any other questions or?
No, that's about it.
Yeah, I do want. Maybe this is a topic for another discussion. But the other thing that people should think about are things like powers of attorney, enduring guardianship documents, and these are not necessarily. Well, while we talk about them a lot in the estate sense, they're not necessarily. They're part of your, I guess, estate planning maybe, but they're not. They don't apply when you die. That's when your will takes into effect. But they are instruments that can assist you if you are ever incapacitated or in a position where you can't exercise these functions for yourself, but you have people, as I said, trusted people, like the type of people you would name to be your executors in your wills. You might also consider whether you have family or friends who you would trust to carry out these activities on your behalf. So powers of attorneys are generally used when you need people to make financial decisions for you, or to sign financial documents, and guardianship documents are usually used for things like medical treatment, the lifestyle decisions, care, that kind of stuff. And look, again, age is not something that I think should be a barrier to those, because they're designed to also come into operation when you might have an unforeseen event in your life. And again, life doesn't discriminate according to age. You never know when you might be getting treatment and you might need someone to make a decision for you. You don't necessarily need to be incapacitated for a power of attorney to have some utility. You might be stuck overseas and need someone to sign something for you. When you are, however, incapacitated in the sense that most people understand that to be, which is, i.e., you might get to a point where you can't make these decisions for yourself, either because of age or some condition or some accident. And that's, I guess, where the younger people need to be. Most younger people are caught by that kind of event. It may be too late to get one done, because if you don't have the capacity to make decisions, and you don't have the capacity to sign a power of attorney, or
even a will,
or a will, or a guardianship document. So the time to think about these is when you are in a position where you can still make those decisions.
Okay, I think also, just before we leave, finish this short video, if anyone has a topic they'd like us to discuss, please let us know in the comments below.
Or you can email us at attorneys@Gramelis, that's GRAM for Mary, ELIS.com.au. Or if you want to connect with us on Facebook or social media, you can always private message us, and we'll endeavour to respond to your queries. Stay safe. In person, whenever we're able to assist you at the other end of this challenging time that we're facing. In the meantime, we're here for you if you need us through technology, whether it be by telephone, by video link, or simply by just emailing us. In the meantime, please feel free to check out our webpage at
gramelis.com.au.
Thanks a lot.